Good afternoon, friends. Let us dive into another case law, that is Satender Kumar Antil versus CBI. Friends, in this case, lot of directions were given, so I will cover only directions. These directions are meant for the investigating agencies and also for the courts. Accordingly, the court deem it appropriate to issue the following directions, which may be subject to state amendments. The Government of India may consider the introduction of a separate enactment in the nature of a bail act so as to streamline the grant of bails. The investigating agencies and their officers are duty bound to comply with the mandate of Section 41 and 41A of the Code and the directions issued by this court in Arnesh Kumar. Any dereliction on their part had to be brought to the notice of the higher authorities by the court, followed by appropriate action. The courts will have to satisfy themselves on the compliance of Section 41 and 41A of the Code. Any non-compliance would entitle the accused for grant of bail. All the state governments and union territories are directed to facilitate standing orders for the procedure to be followed under sections 41 and 41A of the Code, while taking note of the order of the High Court of Delhi dated 7th February 2018 in writ petition civil in writ petition number 7608 of 2017 and the standing orders issued by the Delhi Police, that is Standing Order number 109 of 2020, to comply with the mandate of Section 41A of the Code. There need not be any insistence of a bail application while considering the application under Section 88, 170, 204, and 209 of the Code. There need to be a strict compliance of the mandate laid down in the judgment of this court in Siddharth. The state and central governments will have to comply with the directions issued by this court from time to time with respect to the constitution of special courts. The high courts, in consultation with the state governments, will have to undertake an exercise on the need for the special courts. The vacancies in the position of presiding officers of the special courts will have to be filled up expeditiously. The High Court, the High Courts are directed to undertake the exercise of finding out the under trial prisoners who are not able to comply with the bail conditions. After doing so, appropriate action will have to be taken in the light of Section 440 of the Code facilitating the release. While insisting upon sureties, the mandate of Section 440 of the Code has to be kept in mind. An exercise will have to be done in a similar manner to comply with the mandate of the Section 436A of the Code, both at the district judiciary level and the High Court, as earlier directed by this court in Bhim Singh, followed by appropriate orders. Bail applications ought to be disposed of within a period of 2 weeks, except if the provisions mandate otherwise, with the exception being an intervening application. Applications for anticipatory bail are expected to be disposed of within a period of 6 weeks, with the exception of any intervening application. All state governments, union territories, and high courts are directed to file affidavits, status report within a period of 4 months. So, friends, these were the guidelines which were issued. This is all about this case. Enjoy your life while reading this judgment.